So thank you very much. It's been a real honour to be asked to give the closing address to today. And in true Moot style, I want to propose to divide my time not equally, but between two issues. The first is to give you some comment on the incredible wealth of knowledge that we've heard about today and the thoughts and interchange of ideas that we've been privileged to enjoy today. And the other issue is to perhaps give some reflections on the Vismoot, which I know is something that many of you here today are heavily involved with and devoting your lives to at the moment. And I don't think I'll need to reserve 1 minute for rebuttal. So let me start with perhaps the most important thing that I want to do, and that is to sincerely thank the organisers of today's conference. Professor Eduardo Munoz, who I know has a very hardworking team behind him. Your efforts are greatly appreciated, and thank you very much. We've all been in awe of how wonderfully there's been attention to detail, generous hospitality and thoughtfulness, so thank you. And I think I can say there are very few conferences organised as well and run as well as the one that we've experienced today. And I wish to thank the university also for their generosity and meticulous work in putting together a stimulating day of really thoughtful presentations and discussion. Wonderful venue as well. Thank you very much. I also wish to thank all of today's speakers for your enlightening papers. So much work has been put into it, and I think they'll give everybody here a great deal to think about in the months to come. Now, with that, I'll now make a few remarks about what we've heard today, although I'm going to be very brief because I don't pretend to know as much about many of the topics that we've heard about today or to do them the justice that they indeed deserve. First of all, we had the wonderful warm welcome from Dean Alvarez from the Faculty of Law here. Then we had the keynote address by Professor Schwenzer. And of course, it's always an honour to hear from the professor. In this case, we had a masterclass on the very tricky question of the borderline between the CISG and domestic law. When does the CISG apply exclusively, preempting domestic law? And when can the domestic law apply concurrently alongside the CISG? So not only giving us her views about mistake, initial impossibility, tort and procedural matters, but also the principles behind that view, which is so important. When we take those principles, we can then apply them to lots of different things. We then had panel 1, talking about the addition of claims and consolidation in arbitration. So Diana Correa giving us the historical perspective in the ICC rules and the ICDR rules, and how in common we learnt multi-party arbitrations actually really are, and the manner in which the arbitral rules have to keep up with that and have tried to do so. Then we heard from Ilyana Bardin, who clarified very usefully the concepts of joinder and consolidation, and who makes the decision to allow those things to happen or not, across a broad range of centres on arbitration. And indeed, the questions separated out, can we have consolidated matters or should we have them? Renato Treves also provided us with a really useful comparison of the rules from the SCC, the LCIA and the ICC, and UNCITRAL rules, and even ICSID as well. The similarities and differences to how these work in practice, the extent to which tribunals or parties are limited in their ability to bring new claims or amend claims, and the relevant factors that can be used to argue that matters should be consolidated. And then we had Elisa Ortega, who finished the discussion of the good and bad effects of consolidation in terms of cost, efficiency, and the risks of inconsistency or even just poor quality decisions, and also confidentiality. And I think panel 1 really gave us a really good example of why it's so important to listen and value the learning that we get from practical experience. Panel 2 had a very lively discussion. We started with Francesco Mazzotta, who gave us a great outline of the difficulties that the common law has with good faith and the contrast with the American approach and that emphasis on predictability and how far we go in the development of information duties based on good faith and where common lawyers might be a little bit more uncomfortable with that. Myself on Article 80, of course, and the development of a duty to warn based on information known by one party but not the other, and the risks of losses and breach. And then David Tebble, who talked about and demonstrated information as a basis for liability and also exclusion of liability under various articles in the CISG, but then also developed the view that there might be a general duty to inform in the CISG arising on the basis of looking at specific instances of duties to inform, and then advocating that this extends to a duty to inform to prevent harm to the other party. And then Sophia Young also giving us an intriguing insight on the workings of Spanish football and information duties in that context, in such an emotional and unpredictable and speculative business, which is professional football today. There we find there are some problems from the lack of a duty to inform regarding matters that bear upon the value of players in transfers. We then moved to panel 3 after the wonderful lunch and the break, and then that was, of course, the panel that we've just had on AI and internet security. Julia Villar took us through the definition of AI and the pros and cons of defining AI, and then the really interesting question of enforceability of awards. And I think that's going to be a much bigger deal as we get further and further into the reliance upon AI. We had Louisa Quintal, who talked about the problems from the fact that AI produces outcomes that can be affected by bias in the data inputs and the ethical problems for lawyers. And of course, the beautiful and quite scary hallucinations, which include fake cases, which I have seen being produced in student work too. Joshua Carton talked about the way AI works and how that is different to the way humans and lawyers, which can sometimes be the same thing, how they work. So it's we are glad to know that our jobs are safe for now, but who knows? And then we had from Joshua also the need for critical review of outputs of AI rather than blind reliance, and the use of AI tools by arbitrators when it might be appropriate and when it might not be appropriate to delegate responsibility to AI. And then Marcus Rodriguez also giving us the question of regulation of AI and the view that it should be regulated in the context of arbitration in particular, and the extent to which rules can currently contend with current concerns. And we heard the recommendation that there should be guidelines, and perhaps those are actually on the horizon. So great question and answer section followed that panel, and thank you to everybody who contributed their questions there. So we've heard from voices all around the world. I also want to acknowledge the skill of the moderators today, Gabriela Corzia, Ingeborg Spencer, and also Orlando Cabrera, all providing great questions, teasing out the substance of the issues and keeping everyone on time so that we're not here all night. So with that, I've finished with my first issue, and I want to move to my second one, which is a topic very close to my own heart, which is indeed an issue that brings year after year a combination of the worlds of arbitration and the CISG, and that's the Viz Moot. In the past year, we sadly lost Professor Bergston, who is often referred to as the father of the Moot, but I'm sure the things that I'm about to say would bring a wry smile to his face, because I want to now present an argument to each of you, if it please the tribunal, and my submission is that there is a very close relationship between the Viz Moot and the development of the law, both in arbitration and in the CISG, but I'll take the latter as my case study. And I will produce some evidence to support this proposition, but first, I want to start with some general observations about the Moot, as many of you are now entering into the Moot family for the first time. You might be amused to know a few things. The first thing I want to say is about the topics covered by the Moot problem. Very noticeably, early Moot problems focused on the questions within the CISG of formation and remedies. Whereas in the past 12 years, the focus has been much less on those things. And quite often, in fact, 5 times, we've had the focus being on the scope of the CISG. How far can we stretch the CISG to still fit problems of today? So one of the areas that often gets the focus of the Moot problem is the area of technological change, increased sophistication of goods, and increased complexity of the transactions that we deal with. For example, know-how was one of the subjects of the 2021 Moot. Software was also the subject of the 2014 Moot. And the question about freedom from child labour as a quality of the goods has also been a subject of the Moot. Then we have the goods themselves. Now, for those of us who've been involved with the Moot for many years, this is how we refer to each problem that has happened in the Moot. We refer to it by the goods that were involved. So we've had the turbines Moot, the fuses Moot, the cakes Moot, suits Moot. Indeed, wine has been really popular. That's come up twice, once with added antifreeze. And quite odd goods have been the subject of the Moot. One time we had squid, and another time, believe it or not, we've had horse semen. This year, of course, we've got the sensors. The length of the problem and its format have changed drastically over time. Back in the first Moot, I know this year's Moot, it's 66 pages long, right? Well, in the first Moot, the problem was factual only, and it was 4 pages long, 4 whole pages, with no correspondence between the parties being reproduced at all. There was no procedural documentation. There was no pleadings, no terms of reference. You basically just had to guess what you were arguing about. In 1995, the problem was by then 8 pages long, still no correspondence between the parties. In the third Moot of 1996, we now had a 13-page long Moot with a request for arbitration and a statement of claim, and some extracts from the correspondence between parties as the evidence. 1997, we see something closer to what we see today with correspondence between the parties and 18 pages. And by 2004, we're up to 43 pages in length. Now, some fun facts. In the first Moot, the goods that were the subject of the dispute were the rather salaciously known or named Super Sexto computer chips. In the second Moot, the Moot problem in a note to students hilariously explains that email was a new electronic method of unstructured communication, mostly used for short messages and used by quite a few universities. We've had various countries involved with the Moot. One which has disappeared from view these days is a country called Polarity. And there's been a Dr. Viz as a character in the Moot. And we all know and love the 2 quite incompetent lawyers that keep popping up year after year now, advocating for their clients. Joseph Longweiler did not appear for the claimant, however, until 2002, whereas Horace Fastrack, despite his name, only appeared in 2004. Now, the relationship between the development of the law on the CISG and the Moot. I want to put it to you that there is a correlation between these 2 things. I can't say that that proves causation, but there's definitely a relationship of some type. Sometimes the moot problem picks up on issues previously discussed by cases and authors, whereas other times it tends to be the other way around. So, for example, in the 10th moot, which was about film products, we were asked two important questions on the CISG. The first was, does Article 78 grant the right to claim interest on damages from the time of the breach or only the time of the judgment? And this had been discussed in journals within the years leading up to the moot, particularly in the Vindibona journal by Christian Thiele, who argued that indeed there was a right to interest from the time of the breach, and it was on the basis of unjust enrichment. However, some 10 years later after the moot, we found that we had the CISG Advisory Council Opinion number 14, which in 2013 agreed that the right to interest would be from the time of the breach, but not on the basis of unjust enrichment, instead on the principle of full compensation. The other question raised in the same year was whether the choice of national law was an implied exclusion of the CISG. Some 2 years later, we had articles in the Vindibona Journal on this question. And of course, CISG Advisory Council Opinion number 16 took this issue up a decade after that moot as well. The 20th moot in 2013 was on polo shirts, and it asked the question, can parties themselves agree to contract out of the national reservations declared by member states of the CISG? In particular, in that case, Article 96 declarations to impose writing requirements on parties. So this question had been raised in case law prior to the moot and in various academic journals. 9 years before by Camilla Anderson, 2 years prior in a case, Forrestal, Gurani and Davros in the US, also by a former mootie, Wei Long, in 2 years beforehand in a collection of publications in a book. And in the same year as the moot, Ulrich Schroeder, himself a former mootie, wrote on this issue. And subsequently, he became the rapporteur for CISG Advisory Council Opinion number 15 on this very point, which was also published in the same year as that moot, 2013. So coincidence? I'm not really sure that's a coincidence. 2014, we had the hospital scanning software moot, which asked the question, is software a good for the purposes of the CISG? Now, this had been a contentious question. It had been debated before the moot in a number of articles, for example, in 2003 by Mulbray and by Hiro Sono in the Kritzer Festschrift. And they'd argued, no, it's not a tangible good. Whereas in 2003, we had Diedrich and also in the Journal of Business Law, Green and Seidoff arguing, no, in fact, it can be considered a good. CISG does not have a tangibility requirement. So they argued that mass-produced software should be seen as a good. 3 years following the moot, we had another mootie, former mootie, Thomas Newman, write and propose a new model of deciding whether software was a good, the dominant control model. We then had in 2016 a highly contentious question in the 23rd moot involving wine. Could lawyers' fees be recovered under Article 74? Now, no doubt this had been inspired by a case, Zapata, which had been a US case decided some 13 years before the moot. We had many authors that were writing on this issue, criticising that case, Joseph Luskowski and Harry Fleckner. They'd been highly criticising the Zapata case, saying that the district court had got it wrong to allow such an award under the CISG. But then Judge Posner made a judgment on reversing that award on appeal, sorry. And they said that Joseph Lukowski and Harry Fleckner said, Judge Posner had reached the right conclusion, but for the wrong reasons. He said it's outside the scope of the CISG, but for the wrong reasons, that his reasoning was that it was because it was a procedural matter. Then we had in 2006, the CISG Advisory Council also just looking at this same issue and deciding in Rule 5 that indeed it was outside the scope of the CISG, this question of recovery of lawyers' fees, but not because it was a procedural issue, but instead for other reasons. So this back and forth between the moot problem and academic writing and case law is very, very evident. I'll give you one more example, I think maybe 1.5 more examples, I'll put it that way. 2017, getting quite recent now, jet engine blades. And the question was, is it the seller's responsibility to know and comply with and bear the costs of complying with public law regulations in regard to Article 35(2). Now, this moot was most probably inspired, of course, by the green-lipped mussels case, the famous German Supreme Court case some 20 years before, and the fact that the same issue had been also the subject of a New Zealand case, the Smallman case, some 6 years before the moot. So those cases probably led up to the moot. But also we find that in the very next year after the moot, 2018, we have a CISG Advisory Council opinion number 19, which clarified the factors that should be taken into account in determining whether or not a seller bears the responsibility for compliance with regulations. Things like relative expertise of the parties, the prior dealings within that country and so forth. So again, quite a close relationship between the timing of the moot and the events leading up to it, but also thereafter. And finally, I just want to mention the 2019 moot because it's the one involving horse semen, but also it had a very interesting legal question, and that is, does Article 79 of the CISG allow adaptation in circumstances of hardship? Now, this moot problem was probably inspired by the Belgian Supreme Court decision, a very controversial decision, the Scaffham case. And that case had held that the word impediment in Article 79 included the concept of hardship, but it also decided that the remedy of adaptation was provided for and made that decision on the basis of the CISG. The following, in 2020, in the same year, we had a number of a number of articles on this question. And in the same year as the moot, or the very next year, we had CISG Advisory Council opinion number 20, which the rapporteur for is here in our front row, Professor Munoz, and that taking up the respondent's alternative argument that indeed CISG Article 79 does include hardship within the term impediment, but taking the position that adaptation is not a remedy available under the CISG. So again, the moot problem highlighting a concern in the area of development of the CISG and responses coming in the wake of the moot problem or alongside the moot problem as those arguments are developed. So I put it to you that correlation is indeed not causation, but that the moot does inspire discussion about the development of the CISG, but likewise discussion and where issues become quite debated in the cases and in the scholarship, that can also inspire moot problems. The two are intertwined. And as I've mentioned, many of the authors who are involved in developing this discussion are themselves former Mooties. So what I hope from today is that you've been inspired and I look forward in the future to reading from many of you writing about the CISG or indeed arbitration, which has a similar relationship with the Moot and the development of the law of arbitration. So as this area of law becomes more and more developed, I do look forward to seeing you join that debate as part of the VisMoot family. I wish you all good luck for tomorrow for those of you participating in the pre-moot. And I ask you to once again join me in thanking the organisers of this event for the wonderful experience we've had today. Thank you very much.
Thank you so much, Professor Spagnolo. I really identify myself in several of the things you mentioned about the mood. I was myself a moody. At some point I feel old, at some points I feel very young because I actually, it's 31 years and I did the 20 edition, I think. So it's a time to conclude, but before that I need to acknowledge several people, a group of people that made this possible. I should start with the speakers. Without the speakers, we wouldn't have the discussions that Professor Spagnolo just talked us about and that were so insightful. So thank you so much to all of you coming from different countries as far as Australia, like Lisa, our colleagues from Mexico City as well, Italy, United States, Brazil, Canada, Germany, am I missing? Dominican Republic, Spain, Canada, yes, I already said. I think that's it. It's a pretty diverse group of speakers. And also, I think the highlight is that the vast majority of them were lady colleagues, professors, eminent minds in this field. I think that probably 70% or 60% at least. So thank you very much. The second group of people I need to thank is the attendees, the students, most of them at this room, but also some of the practitioners, former Moody's, current Moody's, and of course, all those that tune in the conference from all over the world. We noticed people from Morocco, India. I mean, India was late and they still were there listening to you. Different parts of Europe, Eastern Europe, Brazil, many from Brazil, Peru, obviously Mexico, United States, and a couple from Turkey. So thank you so much as well to contribute to the development of this program over the years. And without your participation also, it wouldn't make sense to do it. I should also continue with the supporting organizations that are just at the bottom of the screen. They help us to disseminate information about this program, this conference, CR, which is Charter Institute of Arbitrators, specifically the Brazilian branch, the CISG Advisory Council, that is this private initiative, academic initiative that was mentioned several times by Professor Spagnolo at issues important decisions on the CISG, Canaco from Mexico City, which has one of the main arbitration centers, ICC Mexico, of course, one of our main partners for arbitration programs in this university, CAM, the center, the Mexico City Arbitration Center, the Mexican Bar Association, in particular, the chapter from this state, from Jalisco, the Moot Alumni Association that help us to disseminate and yes, spread the word about the program all over the world. And finally, Corredores de Jalisco, which are the commercial brokers. Last but not least, and more important, this event has been prized by being perfectly organized. And the person responsible for this is my colleague, Lupita Ramirez, which is at the back. I want you to have a look at her. She's there. And she's been taking care of the organization of these 3 days, not only today but tomorrow and after tomorrow, for the last probably 7 editions. And to the point that she's the mind and the body behind all of this. The rest of the team, which in the faculty that we work as well in this project, are just helping her because she's got the wheel on everything. So thank you so much, Lupita. We hope we can have you for the next 10 editions. Okay, that would be it. And thank you so much. We hope to count with your participation next year, same week of the year. And thank you, speakers and attendees.